It's a shocking twist to an already frightening story. Wilson Jones was both fired and arrested when school officials discovered he'd allegedly been using photos of his own students to make artificially generated child pornography. Now, as his federal case moves forward, we're learning that he was hired by another state agency that works with kids, and word of his alleged crimes apparently didn't make it to his new employer. We're on the case, presented by Law and Crime. I'm Stewart. Before we get started today, I need to take a moment and talk about our partner and sponsor, Upside, a free app that will give you real cash back when you buy daily essentials like gas and groceries. Upside is so free and easy. I use it when I pump gas. I get cash back there. You go into a convenience store, Upside can work there as well. On top of that, maybe you hit up your favorite fast food joint like Taco Bell and you can use Upside. And we're talking about real cash back. After you spend, money appears in your account on Upside, then you transfer it straight to your bank. So here's what you do. Download the Upside app for free, buy whatever you plan to purchase, pay as usual with debit or credit card, file a claim in the app, and boom, you get your money back. So to find out how much you could save with Upside, click the link in the description or scan the QR code on your screen and use our promo code OTC to get an extra 25 cents back on every gallon on your first tank of gas. This story began in May of 2025 when a grand jury indicted Wilson Jones, a former teacher, and Edward Childress, the superintendent of the Corinth School District, or CSD, in Mississippi. Jones was accused of creating AI child pornography of his own students, while Childress was accused of trying to at least partially cover it up. The case against them highlights the legal implications of AI and the impact that it could have on future investigations. But new documents filed in federal court also appear to expose serious oversights by state agencies. On February 26, 2025, the Corinth Police Department got an email from the Mississippi Department of Education saying there'd been a report about inappropriate behavior by a teacher at Corinth Middle School. That teacher was 30-year-old Wilson Jones. Police followed up with the district superintendent, Dr. Lee Childress, who recognized the incident that they were talking about. The FBI got involved in the investigation and subpoenaed everything the school had that was connected to Jones. According to the criminal complaint, on March 3rd, Dr. Childress, quote, eventually delivered the items. Certainly an interesting use of the word eventually there. Anyway, the criminal complaint states that investigators were able to put together a timeline in November the previous year, around 3 months earlier. The Corinth Middle School principal got a text saying there had been a bark alert on Wilson Jones' computer. Reading from the affidavit in support of the criminal complaint, the Bark app monitors the network of school district computers and scans for illicit content being downloaded or shared. So the app had flagged content on Jones's computer. The IT department was able to access 5 videos that Jones allegedly uploaded to his personal Google Drive account. The videos depicted known Corinth students engaging in inappropriate behavior, including kissing and exposing themselves. The website used to create the images was listed in the file name at the bottom of the images. The next morning, Jones was locked out of his school accounts and his laptop. He met with top school administrators. According to the principal, quote, Jones admitted he created videos using AI, but claimed it was not sexual. A keystroke monitor revealed that in his prompts on the AI site, Jones allegedly said he wanted the girls in the photos to be, quote, garmentless. Investigators identified 8 teenage girls between the ages of 14 and 16 whose photos were taken from social media and morphed into lewd material. All the children were part of the Corinth School District. Despite Jones's claim that the videos he created with students' faces superimposed on nude bodies were not sexual in nature, when federal investigators started digging into his digital footprint, they found thousands of child sexual abuse images that were not AI generated. And now, a flurry of new motions filed in the Northern District of Mississippi is exposing more shocking details. After Jones resigned, he applied for a job with Child Protective Services. The motions have been filed on behalf of Jones's co-defendant, Childress. Basically, He is arguing that not only did he not do anything wrong and didn't cover up the allegations against Jones, but lumping him in with a man who allegedly admitted to police that he created AI images of his own students, he claims the jury would be biased against him from the start. So in this new motion, he wants the info about Jones being able to get a job with CPS to be kept out of trial. The motion reads, quote, on November 20th, 2024, the day after Jones created 5 AI reels, Childress provided Jones with a letter terminating his employment with CSD. As required by law, the termination letter included the reasons for his termination and informed Jones that he could request a due process hearing to contest the termination of his employment. Jones signed a copy of the termination letter acknowledging receipt. The termination letter was permanently included in Jones's personnel file. Later that day, Jones requested to resign in lieu of termination. Consistent with long-standing school district practice, Jones was permitted to resign from his position at CSD, foregoing any right to appeal his separation from the school district. Childress informed the CSD board attorney that Jones had resigned in lieu of termination. After Jones resigned from CSD, he applied for a position at the Mississippi Department of Child Protection Services on February 18, 2025. Jones started his first day of employment at MDCPS as a social service specialist 2. It continues. The fact that Jones, who is charged with possessing child pornography and creating a visual depiction of a minor engaging in explicit sexual conduct, subsequently sought and gained employment with MDCPS is highly prejudicial and will unfairly play on the jury's emotions. This is particularly true since MDCPS records indicate Jones asked them not to contact the Corinth School District. Unfortunately, MDCPS chose not to inquire with CSD as to why a certified teacher left his employment mid-year. Childress was fired as superintendent when the allegations against Jones came to light earlier this year. Now he is charged with misprison of a felony, which means the government alleges that from November 20th, 2024 through January 29th, 2025, Childress, knowing Jones had committed these felonies, acted to conceal them. He permitted Jones to resign and then allegedly misrepresented the reason for that resignation to the school board. But in an interesting twist, another document indicates that Childress plans to claim it was the school district's legal team that instructed him not to report the incident to police. Email records indicate that in February, months after Jones resigned, the school district's attorney, Bill Davis, reached out to the Mississippi Department of Education's Special Assistant Attorney General Jonathan Dennis to get some clarification on who needed to be reporting what and when. See, Jones had already been reported to the Department of Education for a potential violation of the Educator Code of Conduct. The district lawyer believed it was the department's responsibility to then report it to law enforcement if need be. According to emails filed as exhibits in the federal case, the district's counsel cited a concern that reporting a crime that might not clearly fall under the state statutes, especially one involving AI, could open the district up to a civil claim by the former teacher. In his emailed response, Dennis wrote, quote, I understand the Corinth School District's hesitation to report this incident to law enforcement for fear of potential liability. However, as a mandatory reporter, the school district enjoys protection under the law for mandatory reports made in good faith. Dennis asserted that Jones's actions fell under the amended state definition, which specifically incorporates AI imagery. Ultimately, the CSD attorney wrote that they would, quote, wait for MDE to report the incident to local law enforcement and then work with law enforcement as needed. The MDE itself then reported the incident to the Corinth Police Department on February 26th, 2025. Jones and Childress are scheduled to go on trial November 12th. Joining us now to talk more about this case is the District Attorney of Shelby County, Tennessee, Stephen Milroy. Thank you, sir, for taking the time to be with us today. I know this is it's a disturbing case, especially when you think of the implications of artificial intelligence. What stood out to you when you first kind of read through this about just legally how this could play out?
Well, there was a time in years past where the law regarding child pornography didn't reach artificially generated pornography, so-called virtual porn. One of the reasons why there's an exception for that and is unprotected under the First Amendment is that by its very nature, traditional porn involves the exploitation of actual children. And there had been a doctrine that said that virtual porn would be treated differently. But in recent years, both Congress and state legislatures, including the Tennessee legislature, have modified the laws regarding child pornography to make clear that even state-of-the-art artificial intelligence child porn is not allowed to be possessed by anybody, and its mere possession, let alone its distribution, is a crime.
Yeah, I mean, to just think about the faces of his actual students, it's really sick what he's accused of. The FBI got involved in this case. Why would the federal government get involved in this particular case? I mean, I know you're dealing with the internet, you're dealing with artificial intelligence. Was that enough for the FBI to get involved?
Yes, any use of the internet, email, anything like that is considered to be a channel of interstate commerce, which creates enough of a nexus for there to be federal jurisdiction. And because the market for child pornography, both traditional and AI generated, is unfortunately a national market, the federal government definitely has an interest in it. So it's not at all unusual for you to see federal prosecutions in cases like this.
And how often, I mean, has maybe your office seen these types of cases? I mean, now that AI, it's so accessible online, and I know that some of these apps say that there's guardrails that are in place to try to prevent this type of stuff. But I mean, how common is the threat of someone using artificial intelligence for something as twisted as what this man's accused of?
So-called virtual porn, where you would generate a fictional but nonetheless realistic-looking child, has been around for years. And now, more recently, we've been seeing more and more cases of what happened here, where you have a virtually generated child pornography, but you can place a real child's face on the body, which just makes it even worse.
Yeah, and it's good too. It seems like, just from what I've read on this case, that at least this school district had some sort of software that was able to pick up what he was generating to uncover all of this. What do you make of how the superintendent, what he's accused of doing, how he seems to have handled this situation when he was made aware of what this teacher was doing?
Well, so what I understand, and I'm not that close to the case, so I'm only relying on media reports, but he claims that as soon as he found out about it, he reported it to the county attorney or school board attorney or something like that. And, if he did in fact do that promptly, that would be the appropriate thing to do. But not taking action against the teacher, or if it turns out that he didn't really report it promptly, well, then that, of course, is another matter and very troubling.
And it seems like this teacher was able, Wilson Jones, the superintendent Childress says that they were going to fire Wilson Jones, but then he was allowed to resign. And it seems like it was kind of hush-hush, where as a parent, you would want to know if a teacher, what they were doing. I mean, of course, these are just accusations, but you would wish that the school district, I think as a parent, would come forward and be honest about what they say that they found. But the superintendent is facing the same, or is going to be a co-defendant in this case, as opposed to having his own trial. Why is that?
So two things. First, to your first question, it seems like at a minimum, you would want the school system to, make it clear to any other potential entity that might hire this person that they had these charges. I mean, you clearly don't want a person like that, if the charges are true, to be working at another institution where the person would be in contact with children. And so there seems to be some sort of breakdown in communication there, how that happened. Now, as to why the superintendent is a co-defendant, it's an interesting question. I'm not quite sure I know what the strategy was there, and I wouldn't be surprised to see a motion for severance on the part of the superintendent if that hasn't already been filed.
Yeah, because the superintendent, I mean, he's of course accused of not doing enough in the moment where this thing is determined, but he's not accused, to my understanding, of what Wilson Jones is. Another development in this case was that Wilson Jones ends up getting a job with an agency that works with children. And I think there's part of it, there's kind of this like question about the system and how they wouldn't have known. But then at the same time, I look at Jones and what he's accused of, and the fact that he would go into the same line of work. He's innocent until proven guilty, but what do you make of someone who is accused of some pretty concerning crimes, trying to get right back into it and go and work with kids?
Yeah, so obviously, as you said, all people are presumed innocent until proven guilty. But if there is credible evidence, non-trivial evidence, suggesting that this person was in possession of child porn and left the employment of the school as a result, then absolutely what you said is correct. You would think that there'd be systems in place to notify other potential employers of this so that they would be able to take that information into account before making any kind of decision that would employ him working with children in another institution.
How have you seen, and I know you're in Tennessee, this particular story is taking place in Mississippi, but AI is all around us, and sadly child pornography is nothing new, and there's a lot of stories of it. How have you seen law enforcement, as the internet's become faster, this type of technology is now way more accessible to everyday people? How have you seen law enforcement evolve with it and trying to keep up with these predators? Someone allegedly like Wilson Jones, who would even try to get a job again with the school or with a child agency. How do you keep up with these people?
So law enforcement has been keeping up in recent years by creating teams called ICAP teams, where they specialize in being able to look through the internet for signs of this kind of abuse, and maybe even using the internet to trap people that are doing this kind of thing. And then I think the law is catching up. As I said, both Congress and the states have added provisions to their child pornography laws to make clear that AI-generated virtual porn, whatever you want to call it, any of those kinds of things can be treated just the same as old-fashioned child porn. In fact, Tennessee recently passed a law that specified that AI-generated was, added to the definition of a child porn, and penalties have been increased. In fact, if you were actually distributing it, then you'd be guilty of a B felony, which would mean a minimum of 8 to 12 years, depending on your criminal record. And merely possessing it would be a C felony, which would mean a minimum of 3 to 6 years, depending on your criminal record. It could be higher. And then, of course, you could also have federal prosecution in which the penalties are even steeper.
And I know you used to be a law professor at the University of Memphis, and I don't know how often these types of cases came up, but I think that there is a defense attorney for Wilson Jones, and prosecutors have evidence that he was in possession of these images. What is the approach that a defense attorney takes in these types of cases where it seems the prosecution has a very strong case?
Well, either you try to make a credible case that the possession of the materials was unknowing, that he somehow didn't know that he had possession of those materials, or you try to throw yourself on the mercy of the court, try to work out some sort of deal that's in the best interests of the defendant, perhaps acknowledging that there's a sickness that needs to be treated, something along those lines. But in cases like this, it's often very hard for the defense to make a compelling case, because if you can actually prove that the defendant had possession of the materials, and that's pretty hard to rebut.
Yeah, and to your point, I mean, it would be an uphill battle, to say the least. When it comes to the decision that prosecutors have to make, because I know in this world where there's child pornography, that there's someone on the receiving end if those images are being shared, and there may be a bigger fish, for lack of a better term, that prosecutors may want to go after. What goes into the decision if there's some sort of plea deal of making sure that the person who's the suspect in a case, like someone allegedly like Wilson Jones, that you make sure he gets punished, but then at the same time, you can somehow use him for leverage to find someone else to continue to take down a big issue?
Well, Chris, it's really not that different from a drug distribution case or an illegal weapons distribution case. You want to get to the source of the distribution. Who is it that is the major distributor? And if you have the major distributor, then great, then the prosecution and investigation can end there. But if you don't, then you do precisely what you just alluded to, is you try to use the prosecution of the smaller fish as leverage to get them to testify against the bigger fish and, try to go up the chain.
Then just turning back to this case in particular, I know we were talking about if Dr. Childress is able to get his case severed from being a co-defendant alongside the teacher Wilson Jones. What goes into that process where he's clearly accused of, I wouldn't say covering up, but not doing enough? And then you have Wilson Jones who's accused of having the material. I could see someone say that those are two very different cases. What's the argument that has to be made? What's the process after you file a motion of seeing your case separated if that actually happens?
Well, the prosecution, if they wanted to continue to try both cases together, would talk about, the commonality of facts and the commonality of evidence and how it's both efficient in terms of judicial economy and witnesses and everything to try the two cases together. The defendant, the superintendent defendant, I imagine, would argue in a motion for severance that the association with the person that was actually in possession of the illicit material, that would be prejudicial to the defendant by association. And, these facts are so disturbing. We have such a natural, visceral, negative reaction to it that you wouldn't want the jurors to hear too much of that kind of evidence in the superintendent's case. And therefore, there would need to be a severance. And, I'm sure that will be litigated through motion practice and the judge will make the decision.
When it comes to co-defendants in a case like this, is one guilty, both guilty? Or is there a chance that there could be some sort of split decision for the defendants? Or are they in this thing together?
No. There certainly could be a split decision. The judge will instruct the jurors that they have to keep each of the defendants separate and look at the evidence only against that defendant when they render a verdict against that defendant, and in fact have to keep each of the separate counts in the indictment separate. So a split decision is definitely possible in a case like this.
It's a disturbing case. It's one that starts a whole new conversation when it comes to this stuff. Child pornography, child sex abuse material, artificial intelligence. We'll see how this plays out in Mississippi. Stephen Milroy, the Shelby County District Attorney in Tennessee. Thank you, sir, for your time with being with us on Law and Crime. We really appreciate your expertise.
Thank you, Chris.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.